The story begins the way so many suburban nightmares do, with a quiet piece of land and someone else's assumption that it was up for grabs. For nearly 70 years, a stretch of wooded acreage sat just beyond the edge of a growing development outside the city. It belonged to a man named Thomas Hale, not the kind to post online, not the kind to fight over HOA rules. His land was his peace. He'd inherited it from his grandfather, who'd fenced it off long before the neighborhood even existed. To Thomas, it was more than dirt and trees. It was family ground, the kind of place that carried memory in the soil. But to the Maple Ridge Homeowners Association, it was an eyesore, and more importantly, an opportunity. The HOA board had been fighting with the city for expansion rights. Their neighborhood, Maple Ridge Estates, had reached capacity. Every lot built out, every street lined with near-identical houses and manicured lawns. But the demand was still there, and the developers wanted more. The only problem was space. The city's zoning department had limited them to their current parcel boundaries. Beyond those limits lay private land, including Thomas Hale's 20 acres of quiet forest. That was when the line between expansion and encroachment began to blur. The first signs appeared one spring morning, subtle and easy to overlook. Heavy equipment rolled in near the edge of the cul-de-sac. Trucks, surveyors, backhoes. Residents assumed the HOA had finally started work on a new park or walking path. But those who lived closest to the woods noticed something strange. The machinery wasn't stopping at the fence line. By the end of the week, bright orange stakes ran deep into the trees, too deep to still be on HOA land. It wasn't long before the clearing began. The hum of saws and crack of falling trunks replaced the sound of birds. The work crews came daily, moving fast, efficient, and confident. It was as if they truly believed they owned it. The HOA president, a woman known for her get-things-done attitude, assured residents that the land had been properly acquired. She cited permits, contracts, and subdivision plans, all of which she claimed were fully approved. But what no one realized was that those documents had been based on incorrect parcel data. Somewhere along the bureaucratic chain, a developer had submitted plans using a GIS map that extended the HOA's boundary lines well beyond their actual property. The city, trusting the paperwork, had approved it without verifying the deeds. So construction moved forward, illegally, but with all the appearance of legitimacy. When the first concrete foundations were poured, Thomas noticed. He wasn't a confrontational man, but he wasn't naive either. He'd been paying taxes on that land for decades, and he knew his property lines by heart. But instead of storming onto the site or calling the HOA, he did something different. He hired a surveyor, quietly, precisely, and officially. Within days, the results came back, unambiguous and damning. The newly plotted subdivision overlapped his property by nearly 16 acres. 98 planned homes, driveways, and a community center were all slated for construction on his land. The developers had built roads, laid plumbing, and even sold several lots, all under false pretenses. Still, Thomas didn't go public. Not yet. He watched. He watched as the HOA celebrated their Phase 3 expansion. He watched as real estate agents posted listings with cheerful phrases like, "Backs onto private woodland," not realizing that the private woodland wasn't theirs. He watched as the concrete hardened and frames rose into the skyline. To the casual observer, everything looked official. Bulldozers came and went. City inspectors visited. And the HOA newsletter boasted about community growth. But behind the calm surface, a trap was quietly taking shape. Thomas had seen enough to know he was being robbed in broad daylight, but he also knew something the HOA didn't. He understood how land law worked, so instead of fighting with letters or protests, he began building a legal case. He contacted a land use attorney, someone who specialized in real estate fraud. Together, they traced every paper trail: deeds, titles, survey maps, construction permits. They documented every inch of encroachment. The evidence piled up like kindling waiting for a match. The attorney advised patience. The longer the HOA and developers continued to build, the more money they'd pour into structures sitting squarely on private land. The more money they invested, the greater the eventual damages. Every house built without rightful ownership became a future liability, one that could cost them millions. And so, Thomas let them keep going. Weeks passed, then months. 98 homes rose, perfectly lined in rows that gleamed under the sun. Streets were paved, curbs painted, and signs posted. Welcome to Maple Ridge Phase 3. Families started moving in, unaware that they were planting roots in a place that didn't legally exist. By the time the HOA threw their first community barbecue to celebrate, Thomas had already filed everything: quiet title action, notice of trespass, and an injunction ready to trigger. The paperwork sat in his lawyer's office like a silent bomb, waiting for the right moment. And the right moment was coming soon. Because while the HOA thought they had expanded their kingdom, they hadn't realized something crucial. The county tax assessor had flagged the property transfer records. The discrepancy between ownership names had triggered a review. And once the county realized the HOA didn't own the land, the dominoes began to fall. Surveyors were recalled. Questions were asked, and somewhere deep inside the planning office, an uneasy silence began to spread. The HOA still had no idea. They were too busy polishing their newsletter, advertising their new exclusive phase. But Thomas Hale was ready for the moment when every smug board member, every careless contractor, and every overconfident real estate agent would realize they hadn't just built a neighborhood. They'd built it on someone else's property. And when they did, it wouldn't just be a lawsuit. It would be a reckoning, because the land they took wasn't lost. It had only been waiting, and the trap they walked into was already sealed. For months, Maple Ridge Phase 3 looked like a success story. The streets were spotless, the lawns perfectly trimmed, and the HOA board congratulated themselves for transforming an underutilized woodland into a thriving community. On the REIT's surface, it was a picture of progress, bright, symmetrical, and smug. But behind those smiling newsletters and open house ribbons, something had started to creak. It began with the county's annual property audit. Each year, the assessor's office cross-checked tax parcels against their corresponding ownership records. Normally, it was a dull process, but this year, one cluster of parcels didn't match. The database listed the owner as Thomas R. Hale, private individual. The subdivision permits listed Maple Ridge Development, LLC, and the HOA's filings showed Maple Ridge Homeowners Association, Inc. 3 names. 1 patch of land. At first, the clerk assumed it was a clerical oversight, but as the mismatch persisted across all 16 acres, it triggered an internal review. Letters went out, first to the developers, then to the HOA board, and finally to the title insurance company. Most recipients ignored them, assuming it was routine paperwork. Only the title insurer understood what the letter actually meant. The land they'd insured might not be theirs to insure at all. The first tremor of panic spread quietly. Meanwhile, Thomas Hale stayed silent. He'd learned that in these situations, timing mattered more than outrage. His attorney advised him to wait until the HOA committed its next mistake, to let them affirm, in writing, that they truly believed they owned the land. So, Thomas watched as the HOA president signed another round of maintenance contracts, landscaping invoices, and resident covenants, all listing his acreage as HOA common property. Each document became a breadcrumb, leading straight into their liability. Then came the first public crack. A new homeowner, Lot 43, near the southern edge, applied for a permit to build a backyard pool. The county denied it, citing ownership conflict. The homeowner complained to the HOA, which brushed it off as bureaucratic confusion. But within days, more denials arrived. Sheds, patios, fences, all rejected for the same reason. The county's GIS system had been updated with the correct ownership overlay, and now every construction permit touching that land was frozen. The HOA president, certain it was just a system glitch, called a special meeting. She brought in the developer, the project manager, and a representative from the title company. According to records later obtained during litigation, that meeting was the moment when realization began to sink in. The title representative had checked the county archives. There was no recorded sale transferring the land from Thomas Hale to Maple Ridge Development. No quitclaim deed, no purchase agreement, nothing. The HOA had built 98 homes on land still legally owned by a single private citizen. The meeting ended in silence, followed by the first nervous emails. By now, Thomas's attorney had finished preparing the lawsuit. A quiet title action paired with claims for trespass, unlawful improvement, and unjust enrichment. The damages were calculated not by acres, but by structures. Every house sitting on his land represented not just a trespass, but a separate instance of unlawful use. The numbers ballooned quickly. Foundations, utilities, landscaping, property taxes improperly collected. Each dollar the HOA spent was now evidence against them. Still, the HOA refused to believe they'd lost control. They hired their own lawyers, insisting that adverse possession might apply, that because they'd improved the land, they might somehow earn ownership through use. But the problem was time. Adverse possession requires years, even decades, of open occupancy. And Maple Ridge Phase 3 had been standing for barely 9 months. The HOA's lawyers soon realized what the board didn't want to hear. There was no loophole. They had built a neighborhood on land that didn't belong to them. When the formal notice of suit arrived, delivered by certified mail to every board member, the panic became impossible to hide. Residents began whispering. Some had overheard fragments, something about a boundary issue or permits being contested. Others noticed that real estate listings for homes in Phase 3 had quietly disappeared from the market. Mortgage lenders started pulling back, fearing exposure. Then, the first news article hit. A small local outlet published a headline: Homeowners Association may have built on wrong property. Legal dispute pending. What began as an internal embarrassment became a full-blown public scandal. Prospective buyers canceled contracts. Insurance companies froze coverage. A few homeowners, realizing what was happening, tried to sell before the market caught wind, only to discover their titles couldn't be cleared. The homes they'd purchased were, technically, sitting on someone else's soil. Behind the scenes, Thomas and his attorney remained methodical. They didn't gloat, didn't threaten. They simply documented every new consequence, every ripple of damage. Their goal wasn't destruction for its own sake, it was restitution and acknowledgement. But as the weeks passed, the scale of the HOA's mistake kept growing, and so did the potential payout. By midsummer, the HOA's reserves were drained from legal fees. The board held frantic meetings, trying to negotiate directly with Thomas. They wanted a settlement, any settlement, that would let them keep the subdivision intact. But Thomas's attorney didn't respond immediately. Instead, he filed a motion for an injunction, freezing all HOA activity on the disputed property. No landscaping, no construction, no dues collection related to Phase 3. Everything stopped. The neighborhood fell eerily silent. Grass grew tall. Streets went unlit at night. Residents complained, unaware that their HOA no longer had the legal right to maintain their own block. The silence wasn't neglect. It was court-ordered paralysis, and through it all, Thomas stayed composed. He'd spent months watching them build on what was his, powerless to stop it without jeopardizing his case. Now, the balance had shifted. Each day that passed without resolution tightened the noose a little more. Then came the breaking point, a major lender, one that held mortgages for 23 homes in the disputed zone, demanded the HOA repurchase the loans, citing misrepresentation of property title. The HOA didn't have that kind of money. The developer, meanwhile, had already declared bankruptcy after realizing the lawsuit's potential cost. The entire financial scaffolding of Maple Ridge Phase 3 began to crumble. Homeowners, once proudly showing off their brand-new cul-de-sac homes, now faced the possibility that they didn't legally own their own lots. The panic spread beyond Maple Ridge, rippling through the local housing market, and in the center of it all was one man, sitting quietly on a porch that had always been his, watching the chaos unfold on land that was never anyone else's to take. The trap was sprung, but this was only the beginning of the reckoning. Because while the HOA scrambled to negotiate, the courts were preparing to make it official. Titles would be examined, ownership affirmed, and responsibility assigned. And when the judgment finally landed, the HOA would learn that some mistakes can't be landscaped over, no matter how neatly the lawns are trimmed. When the first court date was announced, the Maple Ridge Board tried to downplay it. They told residents it was a procedural clarification, something about boundary verification. But the truth was far less tidy. What was about to unfold wasn't a clarification. It was an autopsy. The courtroom filled quickly that morning. Rows of suits and clipboards, reporters from local outlets, even a few nervous homeowners who wanted to see for themselves if the rumors were true. On one side sat the HOA's legal team, sharp, polished, but tense. On the other, calm and quiet, sat Thomas Hale and his attorney, surrounded by file boxes. What the HOA didn't fully grasp until that moment was how prepared Thomas really was. He hadn't filed a hasty complaint or emotional claim. His case was surgical. Every permit, every deed, every aerial photo was organized in sequence. It showed the story step by step, from the moment the first stake went into his soil to the day the HOA president signed off on the final house. The timeline was devastating. The judge, a pragmatic woman with decades in property law, began asking questions, not just about ownership, but about authorization. Who approved the subdivision plan? Who verified the parcel lines? Who signed the transfer deeds? With each question, the HOA's counsel shuffled papers, deflecting, redirecting, stalling. But Thomas's attorney had already anticipated every gap. He produced the county's survey records. He produced tax statements showing Thomas had been paying property taxes on all 20 acres continuously. He produced correspondence showing that no sale, no transfer, and no lease had ever been executed. And finally, he presented photographs, timestamps showing the HOA's construction equipment digging trenches across property that was clearly marked as private. The courtroom grew quiet as the evidence unfolded like a slow collapse. When the ETE judge asked for the HOA's defense, their lawyers leaned on what little they had left. Good faith. They argued that the HOA and developer had acted under the belief that the land was properly acquired, that the mapping error was a government oversight, that the homes now standing were the result of a shared misunderstanding. But the judge wasn't convinced. Mistakes can explain errors, not trespasses, and not 16 acres worth of them. The ruling didn't come that day, but the writing was on the wall. In the weeks that followed, the case grew bigger. title insurers filed cross-claims against the developer. Homeowners filed against the HOA. Banks filed against both. The legal web tightened until Maple Ridge Phase 3 was no longer a neighborhood. It was a liability zone. Each home represented a potential foreclosure. Each lot a pending dispute. The community that once prided itself on order and control now existed in legal limbo. The HOA's board fractured. 2 members resigned outright, unwilling to face the lawsuits piling up. The president clung to her position, insisting they could negotiate with Thomas directly. She made one last offer through intermediaries, a lowball settlement, a plea for compromise. But by then, it was far too late. Thomas didn't need to bargain anymore. He had already won in the court of evidence. His attorney filed a motion for summary judgment, a legal step that asked the court to recognize ownership without a full trial, since the facts were undisputed. The evidence was so overwhelming that the court granted it. Overnight, Thomas was legally reaffirmed as the sole and rightful owner of all 16 acres under Maple Ridge Phase 3. The news spread like wildfire. Local headlines changed tone from speculation to confirmation. Judge rules HOA built entire subdivision on private property. Within days, panic rippled through the development. Homeowners who thought their mortgages were safe now faced the impossible question: who actually owned their land? Their deeds referenced parcels they didn't legally control. Their home equity evaporated in an instant. Banks suspended payments and froze accounts. Some families packed up and left, abandoning brand-new homes they'd spent their savings on. And yet, the HOA still tried to save face. They issued carefully worded statements about negotiating compensation, about working with Mr. Hale to reach an amicable resolution. But the truth was already public, and public opinion had turned vicious. The HOA president became the face of the debacle, her signature on the construction permits now evidence in every lawsuit. She faced removal by a vote of the remaining board, but by then there was nothing left to manage. The association's funds were drained. Their legal insurance maxed out. Contractors stopped returning calls. The very same residents who once praised her strong leadership now demanded her resignation. Meanwhile, Thomas's legal team began the next phase: valuation. Under state law, the unauthorized improvement of private land entitled the owner to compensation or repossession. In this case, repossession meant everything built on that land now belonged to him. Every road, every light post, every house. The legal concept was clear, but its real-world impact was staggering. Overnight, Thomas Hale wasn't just a landowner. He was the lawful owner of 98 fully constructed houses and the infrastructure beneath them. The court gave the HOA 30 days to vacate and present a remediation plan. When that deadline came, they had none. The developer's bankruptcy meant no one could buy back the property. The banks wanted their collateral protected, but without title clarity, their hands were tied. So, the court's order stood. All property reverted to its rightful owner. And for the first time in the HOA's history, their emails went unanswered. Their newsletters stopped. The neighborhood that once boasted about community harmony now sat in silence. In the weeks that followed, eviction notices went out. Not from an HOA, but from Thomas Hale's attorney. It wasn't cruelty. It was the law. Every occupant had 30 days to vacate unless they wished to negotiate a legitimate lease or purchase agreement. Some refused, some left, and some, remarkably, offered to buy their homes directly from Thomas. He didn't rush those decisions. For months, he'd watched these houses rise from soil that should have remained untouched. Now he walked those same streets slowly. seeing the irony in every identical facade. Where others saw chaos, he saw justice. Not the loud kind that makes headlines, but the quiet, final kind that sets things right. The HOA, stripped of authority, filed for dissolution within the year. Its name vanished from the state registry. The developer's shell company followed soon after. What remained of Maple Ridge Phase 3 was absorbed back into the county record under one name, Thomas R. Hale. The land was his again, changed, but reclaimed. And as winter settled over the empty cul-de-sac, the silence felt different this time. Not the stillness of trespass, but of closure. Because the trap he'd set had finally closed. Not with fury, but with finality. When the ruling became final, the story of Maple Ridge, Phase 3, spread far beyond the county line. News outlets framed it as a modern parable, the small landowner who outsmarted the HOA machine. Commentators argued about zoning failures, legal loopholes, and arrogance. But for Thomas Hale, it was less about spectacle and more about restoration. He hadn't set out to ruin anyone. He'd only wanted what was rightfully his. But as the dust settled, he realized the scope of what had landed on his shoulders. 98 houses, 16 acres of paved streets, power lines, drainage systems, even playground equipment. All now his property by court order. Owning it was one thing. Managing it was another. The first weeks were chaos. Former residents called constantly, begging for clarity. Some wanted to stay. Others demanded refunds they'd never receive. Mortgage lenders flooded his attorney's office with letters, all desperate to protect their investments. Each claim added another layer of paperwork, and each piece of paperwork reminded Thomas of how recklessly the HOA had gambled. But beneath the confusion, something else began to form. An opportunity. Thomas wasn't vengeful by nature. He'd spent most of his life quietly, rarely confronting anyone. Yet, as he walked through the silent cul-de-sacs that had once bustled with HOA pride, he saw potential. The roads were solid, the houses structurally sound. Families had lived here, even if under false pretenses. Wiping it all away wouldn't undo the past. It would only repeat another kind of waste. So, he decided to rebuild, not in wood and concrete, but in structure and principle. The first step was a public notice. Through his attorney, Thomas announced that all properties within the former Maple Ridge Phase 3 would be reclassified as part of a private community trust. Former homeowners would have first rights to repurchase their houses directly from him, this time through legitimate transactions. The terms were strict but fair. Updated market value, verified deeds, and zero HOA governance. The reaction was mixed. Some families, drained from the ordeal, refused to return. They'd lost too much, emotionally and financially. Others, weary of the HOA's suffocating control, saw a chance at redemption. A clean slate without the politics and power games. Slowly, offers began to trickle in, and as each sale closed, something remarkable happened. The neighborhood began to change, not in appearance, but in atmosphere. The iron grip of the HOA had been replaced by quiet independence. There were no inspection rounds, no fines for mailbox colors, no mandatory lawn length requirements. Instead, residents took care of their homes because they wanted to, not because someone else demanded it. Word spread online. Videos and podcasts dissected the saga. Real estate blogs called it the Great HOA Collapse. Property law professors cited it in lectures. Comment sections turned it into legend. Don't mess with the quiet guy who knows his deeds. Meanwhile, the former HOA board scattered. The president, once the self-proclaimed guardian of community standards, faced personal lawsuits from residents who claimed she'd misrepresented property ownership. Her leadership career in homeowners management ended overnight. She sold her own house in the neighboring phase at a loss and moved away, leaving behind the ghost of her empire. But not all who'd been involved left bitterly. Some of the construction workers returned to help Thomas repair what the legal war had left behind: cracked sidewalks, neglected landscaping, and rusting light poles. They worked under new contracts, this time with every permit carefully verified. It was ironic. In a way, the very people who had unknowingly trespassed were now helping restore the place under the rightful owner's authority. Thomas oversaw it quietly. He rarely spoke to the media, even as the story gained national traction. When asked for comment, his attorney's simple statement became iconic. He didn't build a trap. He just refused to move from his ground. The repairs took months. Each street regained its shape. Each lot regained its legitimacy. And through it all, Thomas treated the process not as revenge, but as reclamation. When the first family moved back in under a legitimate deed, there was no ceremony, no cameras, just keys handed over with a quiet nod. Over time, more followed. Some bought back their former homes. Others purchased new ones from Thomas directly. Within a year, over half the houses were occupied again, not as a subdivision controlled by a board, but as a real neighborhood owned by individuals. The property values slowly stabilized. The media attention faded. But among real estate circles, Maple Ridge Phase 3 became a cautionary legend, a textbook case of why paperwork mattered more than power. As for Thomas, he kept 10 acres for himself, a mixture of forest and cleared space where his grandfather's old cabin still stood. He built no walls, no gates, no HOA office. He left the roads open and the land breathing. Occasionally, he'd receive letters from law students or homeowners who'd read about the case. They called him the man who outsmarted the HOA, the landowner who fought back. But those titles didn't sit right with him. He hadn't outsmarted anyone. He'd just been patient enough to let others undo themselves. The financial settlement, once finalized, was immense. The insurance companies, desperate to close their exposure, paid damages not just for the encroachment, but for the emotional distress caused by the ordeal. By the time the accounts were cleared, Thomas had gained more than money. He'd gained freedom, the ability to choose what happened to the land without interference. One autumn evening, nearly a year after the judgment, he walked the length of the property line. The air was cool, and the leaves rustled softly in the fading light. Where the orange survey stakes had once pierced the soil, now stood small wooden posts engraved with brass plates. Hale Property Boundary, 1954, present. They weren't warnings. They were reminders, because in the end, it hadn't been a war between neighbors. It had been a lesson in boundaries, both literal and moral. And though the HOA had vanished, the story continued to echo in online retellings, in whispered homeowner forums, and in every cautionary post that began with the same warning. Make sure you know whose land you're building on. The trap had never been about vengeance. It had been about patience. The kind of patience that watches others dig their own hole and simply waits for them to realize they're standing in it. And when Thomas finally locked the gates to his property that night, he did so not as a man seeking closure, but as someone who had already found it. Because justice in his case didn't roar. It waited. Years passed, but the story of Maple Ridge Phase 3 never really faded. It lived on the internet, clipped, narrated, dramatized. A cautionary tale wrapped in suburban irony. Every few months, a new video would resurface with a familiar title: The HOA That Built on the Wrong Land. Viewers would shake their heads in disbelief, some laughing, others wincing. But for Thomas Hale, the noise had long since quieted. The land had grown peaceful again. By the third year after the judgment, the last of the legal remnants had settled. The lawsuits between lenders, insurers, and former board members dragged on in the background. But they no longer involved him. His name had been cleared, his ownership cemented, and the title dispute that once rippled through the entire county was now a closed case. What remained was something simpler. The old subdivision, stripped of its HOA identity, had evolved into what residents jokingly called Hale Hollow. A team, loose-knit community without bylaws, without dues, without committees. There were disagreements, of course. Fence heights, street parking, the occasional noise complaint. But people handled them the old-fashioned way, with a conversation, not a fine. There was freedom in the imperfection. Thomas rarely walked the full property anymore. He didn't need to patrol or prove anything. The boundaries were set, the markers firm. The same neighbors who once eyed him suspiciously now waved when they saw him. They understood, in their own way, that the neighborhood existed only because he had defended it from the people who tried to control it. And yet, the irony never stopped fascinating outsiders. How could a group so obsessed with order destroy itself through arrogance? How could the so-called enforcers of rules fail to follow the most basic one? To check whose land they were building on? The answer was simple, and it lay in every cracked document, every forged assumption. They never thought they could be wrong. The HOA, in all its rigid confidence, had believed ownership was a formality. They trusted their paperwork, their process, their collective authority. They forgot that real authority comes from truth, not titles. Thomas understood that better than anyone. He'd lived through the months of silence, watching bulldozers tear into his land while everyone else looked the other way. That memory still lived in him, quiet but unshakable. But instead of bitterness, it gave him perspective. He began donating small parcels of his remaining land to local conservation efforts, areas untouched by the construction, rich with old oak and pine. The woods his grandfather had once walked were now protected by law, immune to any future developer's ambition. The county even installed a sign along the trailhead that read, "Hale Preserve," dedicated to the stewardship of land and law. People came to hike there on weekends. Sometimes they'd recognize the name from the viral story and whisper about it as they passed. They never saw Thomas. He kept his distance. But he'd sometimes sit at the edge of the property, hidden by the trees, and listen. Hearing strangers tell his stories secondhand felt strange, like listening to an echo of a storm long gone. But what struck him most wasn't the exaggerations or dramatizations. It was how people reacted. Most didn't mock the HOA. They talked about boundaries, about respect, about how easy it was to overlook the quiet people until it was too late. In a world of instant outrage, his patience had become the rare thing people admired. Meanwhile, real estate developers across the state changed their procedures. Title verification became mandatory for every phase of new construction. Counties updated their GIS systems, requiring direct deed verification before permits could be approved. What had once been an overlooked step was now law, all because of one man's refusal to be erased. The story had become legend. But legends always distort the truth. Some online versions painted Thomas as a vengeful mastermind who planned the trap from the start. Others turned him into a tragic figure who lost his land to bureaucracy. The reality was quieter, steadier, and far more human. He'd simply stood his ground, and when the world refused to believe him, he'd let the evidence do the talking. Now, every year on the anniversary of the court ruling, a small group of law students visited Hale Hollow. They'd walk the roads, study the parcel maps, and marvel at how an entire suburban development could exist on land that once belonged to someone else. For them, it wasn't just a legal case. It was a reminder of how fragile power becomes when it stops respecting the truth. Thomas never attended those visits. He didn't want the spotlight. But one spring afternoon, he left a note on the trail bulletin board. unsigned except for his initials. It read, "The land doesn't care who claims it. It only remembers who respects it." He went home, brewed a cup of coffee, and sat by the porch of the old cabin, the same spot where he'd once watched the bulldozers move in. The woods had regrown now, softer and quieter. The hum of machines had long been replaced by bird song. From where he sat, he could see the rooftops of Hale Hollow in the distance. Homes once stolen, now redeemed. Children played in yards where survey flags once fluttered. A postal truck rolled slowly down the street. It looked like any other neighborhood in America, and that was the point. Peace doesn't always look dramatic. Sometimes it's just the absence of conflict, the quiet after a storm. As the sun sank, he thought of his grandfather's words. "This land will outlast every cul-de-sac." He smiled at the irony. The cul-de-sac had come and gone, and yet the land remained, changed, but still his. The world might remember the story for its drama, the lawsuits, the downfall, the headlines. But for Thomas, the real ending was simpler. The land was whole again. No board meetings, no fines, no authority except the kind written in the soil. And though the HOA had long since vanished into bankruptcy records and footnotes, its ghost lingered as a lesson to every new developer, every overconfident committee, every neighbor who mistook control for ownership. Because Maple Ridge Phase 3 had proven one truth the world wouldn't forget. You can pave over the earth, redraw its lines, and rename its streets. But if you build on what isn't yours, it will always find its way back. The land remembers. Always. And on that quiet evening, as the last light caught the brass markers along the boundary, Thomas Hale sat still. Not as a man who'd won, but as one who'd endured. The trap had closed years ago. The reckoning had passed. All that remained was peace.